Yes, what is this pretty multicoloured document we've got?
My Lord, that is for insertion in the 4th volume of the supplementary bundle. Your Lordship may recall that yesterday my learned leader, Mr. Davey, was making submissions by reference to that document, but one of the references was wrong.
Oh, yes.
The text in
So
red.
this is going into volume?
Volume 4 of the supplementary bundle, page
1014. Okay.
And has it been updated on the electronic bundle?
No.
Could I put in a plea that be done?
Yes, of course.
Thank you.
Right.
Your Lordship also has a purple folder, which is the hard copy transcript from yesterday.
Purple folder. Yes.
My ladies, when I finished my submissions yesterday, we just finished looking at the Court of Appeal's judgment in Barclays Bank. My Lady Justice Falk asked me a question, and on looking back at the transcript, I'm not sure I answered it, so I want to make sure I have. My lady asked me whether I'm saying that if one is in the scope of the exclusion, does that remove the expenditure altogether? My answer is that if an item of expenditure is within the scope of an exclusion or is otherwise connected with non-qualifying expenditure, that precludes the item of expenditure from qualifying altogether, unless it's possible to apportion the item of expenditure into exclusively qualifying and exclusively non-qualifying components. So if you can apportion, the qualifying and non-qualifying connections can coexist because you've managed to apportion it into those two components. And that's the nature of the apportionment exercise that my client's inviting the court to take. It's taking an item of expenditure, say 100, and it's apportioning it into exclusively qualifying and non-qualifying elements. So if you have an item of expenditure that's connected with an exclusion, then none of it qualifies unless one can get into that apportionment exercise. That's the answer to my lady's question. So when we finished yesterday, I said there had been various cases which have relied upon the principles set out in Coventry in the Barclays Bank case. The key point from the authorities is that, as the first tier tribunal said in the case of JA and Young Limited at 73, and as the FTT cited in this case at paragraph 151, the degree of connection, the remoteness, proximity and type of connection required by the use of the phrase in connection with in a particular statute must be identified from the particular statutory context in which it's used. So turning now to HMRC submissions, we have here a particular statutory context, which is to provide allowances to subsidise the renovation or conversion of qualifying buildings. And my submission is that the focus of the legislation, the statutory context, is on improving the physical state of the building. And my submission is that one sees that simply by looking at the words of the legislation. There are 4 key provisions in play, beginning in the authorities bundle at page 7. We have section 360A, which provides that allowances are available under this part if a person incurs qualifying expenditure in respect of a qualifying building. Page 7.
Yep.
Over the page, we have section 360B. The court has seen that key concepts in this section are concepts of conversion of a building, renovation of a building, repairs to a building. These are in my submission all references to physical works. At page 10 of the authorities bundle, there is section 360C. And in subsection 1, there is a specific reference to any conversion or renovation work. And at page 12, we have section 360D, which provides the definition of qualifying business premises. And subsection 1 refers to those premises being a qualifying building. While we're here, can I ask the court to note, because it will become relevant later on, that in order for premises to be qualifying business premises, subsection 1B provides that the premises must be used or available and suitable for letting for use.
Yes.
So my submission is that the focus of the statutory language is on converting or renovating a building which has been unused for a year. Now, as regards the IFA and promoter fees, my submission is that those fees don't have the necessary degree and type of connection to the conversion works to Blush House to qualify. And in particular, my submission is that there are two components of the in connection with test which are absent in relation to IFA and promoter fees. The first component is that the expenditure must not be too remote from the renovation or conversion of a building. And the second is that the expenditure must have a natural, a real-world connection to the renovation or conversion of a building. And my submission is that neither of those necessary components is present in relation to the IFA and promoter fees.
Is the second simply another way of putting the first?
They're related. They're certainly related. I don't know if they're quite the same point, but they're complementary. So the starting point, I'll take those in order, so starting with the remoteness argument. The starting point is to consider the nature of this expenditure. And the expenditure has been incurred in my submission to market membership of the LLP to high net worth individuals. It's akin to a marketing fee paid to market to members. Membership of this club. Members pay their membership fee. They join the club and they get two things. They get to shelter their income from tax, and they get an interest in a hotel business for at least 8.5 years. If I may, I'd like to go to a couple of documents in volume 2 of the supplementary bundle just to give some further context to this. The first is the information memorandum, which is at page 359 behind tab 19. Page 359 is the cover page, and at page 363 there's an executive summary. The second paragraph gives some background for what the LLP will do. So it will acquire the property and refurbish it, enable it to be operated as a Ramada Encore hotel, and a wholly owned subsidiary will take a 25-year lease and operate it under a franchise agreement. On the penultimate paragraph on this page, you can see that the property must be held for a minimum period of 7 years. It's likely that the earliest disposal date for investors will be approximately 8.5 years. That's where I get the reference to members having an interest for at least 8.5 years. And then the final paragraph on this page sets out how, for a gross investment of £100,000, what members have to put in is, in net terms, £6,087. once one takes into account BPRA and limited recourse borrowing. Just for your notes, this is the source of the figure in paragraph 2 of our appeal skeleton. So that because in paragraph 2.1 of my own friend's response skeleton, so that figure isn't recognised, but this is the source of it. So that's the information memorandum. Tab 16 of this folder we have a document produced by IFAs. So IFAs take the information memorandum and a tax shelter investment guide is produced and sent to clients. Pages 339 to 341 relate specifically to BPRA schemes. Interested clients then gets a calculation showing how much tax they can shelter. One can see that behind.
Sorry, can you give me the page number?
I apologise. In the tax shelter investment guide, it was pages 339 to 341. And behind tab 24, at page 457, there's an email exchange between an IFA and a prospective client. Begins by calculating taxable earnings for the year.
Sorry, 455?
457.
457. Beg your pardon. Yes.
So it begins by a calculation of earnings for the tax year. And then it says, I've calculated a number of figures. The figures are below what you would need to subscribe to either wipe the 50 and 60% bands out, or to wipe the 40%, 50% and 60% bands out. You can work out the cash required yourself from whatever gross contribution you wish to shelter by multiplying by 0.46 for Luton. And for your note, behind tab 29, page 490, is a letter from an IFA giving a more detailed illustration of the relevant figures. So that's what these fees are paid for, in which the LLP is seeking to claim the BPRA on. Now, obviously, the membership fees that members pay for admission to this particular club get used by the LLP for a host of things. They go into a pot alongside borrowing from various sources, and they fund in part the acquisition of the land, they fund in part the legal fees incurred to purchase the land, they fund in part the costs of advertising the LLP to members, and they fund in part the expenditure on converting and renovating the hotel. But the fact that the membership fee for this particular club is used in part to fund qualifying expenditure, along with a whole host of other things, does not, in my submission, give it a sufficient or sufficiently close link to the renovation or conversion of a building. In my submission, there is a line to be drawn between...
It doesn't give all of it, I think, is what you mean. It doesn't give all of it a sufficient connection.
Well, I'm in my primary case, which is that none of it qualifies. It's all too remote. All of the fees are too remote. So I'm not into...
No, the fees, I follow, but you're talking about the pot. which funds a number of different things, including the works. And I think what you mean is that not all of the pot qualifies.
Indeed. Yeah. My submission is that there's a line to be drawn between expenditure incurred on the setting up of a structure, the LLP, on the one hand, and the expenditure that that structure then goes on to incur. This expenditure is neither directly connected to the renovation or conversion of the building, nor exclusively connected to it. I do say that the proper purpose of construction and application of this legislation is informed by the fact that the focus of the legislative scheme is on converting buildings and so on. And in my submission, it's difficult to see when enacting this legislation, using the language that we've seen, that Parliament kind of intended to inspire the creation of these tax shelter structures, let alone intend to subsidise the creation of them. Now, as regards to the second component of the in connection with test that I submit is lacking in relation to the IFA and promoter fees, and that's a real-world natural connection to the renovation or conversion of a building. The starting point is that, as the court is well aware, there has been, for decades from the House of Lords and Supreme Court, a consistent message, grounded in Lord Wilberforce's speech in Ramsey, that tax is generally imposed by reference to economic activities or transactions which exist in the real world. One sees that in a whole host of cases, BMBF at paragraph 34, UBS at paragraph 64 and 78. So Parliament legislates in the real world in respect of real world transactions. So what is Parliament legislating for when it enacts this on or in connection with test? My submission is that what Parliament is intending to catch with this legislation is expenditure like architects' fees, surveyors' fees, things which may not be caught by an on test, but is expenditure which is naturally connected with the conversion or renovation of a building. And expenditure on IFA and promoter fees does not exist in the real world in connection with the renovation or conversion of a building. And that submission is firmly grounded in the expert evidence in this case. We had expert evidence from both sides on this very point, and the experts spoke as one. I'd like to show you that very briefly, starting with the expert evidence given by the appellant's expert, the LLP's expert, Mr. Smith. Mr. Smith's report is in volume 3 of the supplementary volume. It begins at page 858 behind tab 57. And if we could pick it up, please, at page 864. At paragraph 4.16, apologies, 4.14, Mr. Smith says that the financial appraisal of development projects is often carried out using either proprietary or bespoke tools, and he then makes reference to a software package known as Argus Developer, and at paragraph 416, there is a list of heads of cost in that Argos developer software package. And essentially, this is a list of costs typically associated with real-world, straightforward commercial property development. And the key point to note is that IFA and promoter fees aren't on this list. It's skipping forward to page 873, Mr. Smith turns to address the IFA and promoter fees. Can I invite the court please to read paragraphs 4.74 to 4.76?
Yes.
So Mr. Smith says that in enterprise zone and BPRA transactions, these are costs met by a developer using the funder's money. That's his evidence. And his conclusion is on page 875, paragraph 5.3.4, where he says that his experience of tax-driven investments is that it's industry/market standard. Mr. Smith gave oral evidence. I'd like to show you the relevant passage from that, which is in the 4th volume of the supplementary bundles.
I've lost track. Who does Mr. Smith, who was he instructed by?
The LLP.
Volume 4.
Tab, yes, my lord. Volume 4, tab 83. Page 937. Internal page 44. Picking things up at line 23. So Mr. Smith is cross-examined in relation to the IFA and promoter fees. I'll read out the relevant passages. He's asked if we could move to your report at page 194. You deal with IFA, legal and promoter fees. I suggest to you that in the Argus list that we looked at earlier, which is paragraph 4.16 of your report, there was no mention on the Argus.
Internal page.
I was on internal page 44, starting at line 23.
Sorry, thank you.
And it was put to Mr. Smith that in the Argus list, I'm now over the page, internal page 45, there was no mention of IFA and promoter fees. Mr. Smith says that's correct. Argus is not an appropriate way of dealing with an enterprise zone or BPRA project appraisal. It's put to Mr. Smith that the reason they're not on that list is that they're not normally allowable development costs.
So he's distinguishing between tax-driven and non-tax-driven projects.
He certainly is. And the key point is lines 7 to 22 on page 45.
Yeah.
And in particular, the evidence IFA and promoter fees are not normally associated with non-tax-driven activity. So that was the evidence on behalf of the LLP. I'll give you the references to the expert evidence given on behalf of HMRC. That's Supplementary Bundle Volume 3, tab 55, page 722.
Do you want us to turn it up?
Not unless your Lordship would like to see it. It's paragraph 9.6.3. That's Mr. Williams's report. He expresses surprise at these forming part of the development sum and says they're not connected with works of conversion or renovation. In cross-examination, it was put in that was ultimately a matter for the tribunal with which he agreed.
Which paragraph? Because I'm on page 722, you don't get to paragraph 6.3, which is what I noted.
9.6.3.
Yep.
page 722, para 9.6.3. So in terms of where the expert evidence takes us, we have this distinction between tax-driven activity, i.e. the promotion of tax shelter structures. One sees IFAing promoted fees. But in connection with straightforward, ordinary commercial property development, one doesn't find IFAing promoted fees. And that's essentially a matter of common sense. It would be very, very strange if one was speaking with a developer and saying, developing this building, I pay a great deal of my IFA fees. Something one only sees in the context of these tax-driven structures. And my submission is that Parliament isn't legislating when it uses the language of in connection with renovation, conversion, repair. It's not legislating in the world of tax-driven structures. That's not what this legislation is aiming at. Before I turn to show the court how the FTT and duty dealt with this argument, I would like to show the court some passages from Benedetto on which my learned friends place some reliance in their skeleton argument. It's in the Authorities Bundle, Volume 1, tab 23, page 130.
Yes.
So this case is about whether capital allowances could be claimed on interest and commitment fees on bank lending that was used to finance the acquisition of an oil rig.
You can take it that we have read the case.
Okay. In that case, I'll just show the court the passages on which I place reliance and then summarise the points of principle that I respectfully suggest can be taken from it. If one starts with the speech of Lord Wilberforce, one can see that bundle page 132, let us see the loans in question were exclusively applied to the financing of the acquisition of the asset. And importantly, at page 134, his lordship makes, beginning at letter E,
Yes.
essentially a policy or principle-based argument against allowances being available between letters A to G.
Equality of treatment.
Yes, so in summary, his lordship is not keen on construing the legislation so as to allow different taxpayers to get different allowances for the same activity, depending on how they structure their arrangement.
Yeah. Lord Hailsham says much the same thing.
Your lordship is ahead of me.
As I say, we've read the case. Page 136, G to H.
I will skip forward to what I respectfully submit can be taken from this case rather than showing you the sideline passages. Then. My submission is that there are two things that one can take away from Benedetto. The first is the obvious point that there are a number of key differences between this and the present case. The first is it's not legal on all fours. It concerns different legislation with an on test rather than an honorary connection with test. And the legislation is designed to do a different thing. It's designed to, the purpose is to subsidise the acquisition of an asset rather than subsidise works of renovation or conversion. And the second difference is factually, it's different. It concerns fees that are directly and exclusively incurred in connection with the qualifying activity, which is not the case in relation to the IFA and promotion fees. But the second thing, which is more relevant that one can take away from the case, are the issues of principle that their lordships grapple with. And there are two, they're related. The first is concerns about construing the capital allowances code in such a way that will allow significantly greater allowance is to be claimed simply by reference to the particular structure adopted by the taxpayer. And secondly, their lordships express concerns about the possibility of abuse, by which they mean additional layers or additional types of cost being the subject of claims for allowances and of the inflation of reported qualifying expenditure as a result. And I do submit that one can read across those concerns when considering the expenditure in issue in this case. We're dealing with a claim for BPRA in respect of IFA and promoter fees of almost £700,000, which is almost 12% of the 5.8 million it costs to renovate or convert the building into a hotel.
This was a point, I think, that you put before the FTT in your skeleton argument, but as far as I can see, it's not dealt with either by the FTT or the UT. Is that right?
It's right that the FTT didn't deal with it. The UT may have dealt with it indirectly. They haven't grappled with Benedetto. That's certainly right. That's certainly right. One final point in relation to Benedetto, it's relevant to note that Lord Salmon, who dissented, did so on the basis that the fees in question were a common feature of the transaction. So, for his lordship, the concerns about abuse and so on didn't arise on the facts.
Yeah.
Now I'll turn to the FTT and UT decisions. Starting with the FTT, which is in the core bundle 18, page 347.
Would you repeat the page number?
347.
347.
The heading at paragraph 197, and in essence 197 to 199 is a summary of submissions. Paragraph 200, I've written in the heading decision. That's the decision in relation to the IFA fees. Paragraph 202 is a summary of submissions on promoter fees. And 203 is the decision on promoter fees. And there are essentially two steps to the FTT's decision. First, it says that it agrees that there was no need for the payment to be structured in this way. Second sentence, para 203. See also para 200, first sentence. Now, I believe that to be a reference to my client's argument that it's really quite odd to have a situation where the LLP's promoter is liable to pay the IFA fees.
Well, I think that he said that's because he's the one who's regulated by the Financial Services Authority.
Indeed. That isn't the oddity. The oddity is that so the LLP's promoter has the liability and it's going to use the LLP's funds to pay the fees. But the payment is channeled through the developer. So LLP pays developer, the developer to pay the LLP's promoter. Why not LLP pay the LLP's promoter directly? And our answer to that question is that it's because by paying via the developer, the aim in our submission is to clothe the fees with a connection to the conversion works which is lacking in the real world and to bolster the BPRA. So the FTT...
Sorry, just to stand back, you're saying both the promoter and IFA fees would naturally, are you saying, all fall on the LLP? And would more naturally be paid directly? Can you... I don't know if there's a distinction between the two sets of fees.
So the IFA fees are the liability of the LLP's promoter, down in. So the submission in relation to the structure... But
it would normally discharge them out of its fees.
Indeed. But rather than the LLP paying the promoter directly, for the promoter to be put in funds to pay the IFAs, it's channeled through the developer as part of the development sum.
It comes to the same thing in the sense that the LLP would normally bear. The LLP is liable for the promoter fees on the face of it, absent the contractual framework. It's the promoter of the LLP. Who is the promoter going to bill? It's the LLP. And and out of its fees, it would normally pay the IFAs. Is that a reasonable way of looking at it?
My lady, yes. And I agree. Whether it's the liability of the LLP or the LLP's promoter, in either case, the submission is, why is it being channeled through the developer?
Yeah.
So I said there were essentially two steps to the FTT's decision. The first is it agrees there's no need for the payment to be structured in this way. It doesn't grapple with the substance of the submission, which is that's revealing of something here. What the FTT says at paragraph 200 is, had such sums been paid directly by the LLP, they would either be deductible revenue expenditure, or given the wide interpretation we've adopted of the statutory provision, expenditure incurred in connection with the conversion, etc.
So they're rather hedging their bets on it, because if it's revenue, it can't be BPRA.
Again, your lordship is ahead of me. My submission is that the first limb of that decision is irrational. It was the LLP submission that if the fees had been paid directly, they would have been deductible revenue expenditure or in connection with, and so on. The FTT appears to have accepted that submission, but on that basis, the fee shouldn't have qualified for BPRA at all, because it's not capital in nature. So that part of the decision holds no water at all. As regards to the second ground, we essentially have a conclusion without analysis, other than in connection with us to be given a wide interpretation. For the reasons I've given, my submission is that the FTT is misconstrued in connection with, which is an error of law. So they just say it's wide, but they haven't considered or reached the correct conclusion on the degree or quality of the connection required. And it's interesting to note, if one skips forward to page 350, and here I'm trespassing into franchise costs, but it's relevant to everything. Paragraph 209, first sentence, the FTT appears to have dismissed the idea that it needs to consider sufficiency of connection at all. If one goes back to paragraph 200 at page 348, there's a cross-reference to an earlier part of the decision, paragraphs 147 to 145, where the FTT essentially sets out authorities that have considered in connection with. We could just go there very briefly, please.
To those paragraphs.
Yes, so page 237.
Yes.
Now it's paragraph 146 that I want to show you. So just before they start working for the authorities. And about halfway down this paragraph, towards the end of the paragraph, penultimate and final sentences, they say there's nothing in the legislation to restrict the interpretation of qualifying expenditure to that incurred on or in connection with physical works. Now, my submission is that that is a wrong construction of the legislation. I should just make very clear that the recitation that HMRC accepted that is inaccurate. It was our case that the FTT was rejecting. So we did not and have never accepted that there's nothing in the legislation to restrict the construction of qualifying expenditure to that incurred on or in connection with physical works. That's our argument.
Well, the first two, those last two sentences don't seem to add up, do they? Having said that there's no restriction on in connection with physical works, they then say, but we've got to consider what in connection with means. In connection with what?
Indeed. It's a
Physical
submissions
works.
that the FTT goes wrong in law here.
Yeah.
For the reasons I've given, the FTT erred in finding that the IFA and promoter fees were qualifying expenditure. Turning to the UT's consideration of this point, the UT's decision is behind tab 12. And at page 229, the UT begins its consideration of this expenditure. And over the page, under the heading discussion, we have at paragraphs 283 to 286, the UT's decision on HMRC's primary case. The UT's key conclusion is the final sentence at paragraph 286. And my submission is there's an error of law that underlies that conclusion. There appear to be two main building blocks which underlie the conclusion. The first is what the UT says at paragraph 285, where the UT says there's no warrant in the legislation for restricting BPRA in the way which HMRC advocate. Indeed, HMRC's approach would operate to restrict and reduce the effectiveness of the regeneration of disadvantaged areas, which was the underlying rationale for it. And that, I think, is what the UT is getting at when it refers to the purpose of the legislation in paragraph 286. And my submission is there are three errors made by the Upper Tribunal in relation to this. The first is that HMRC's construction of the legislation is very much based on the wording and purpose of the legislation. So it's not that HMRC is seeking to take the legislation and then narrow it. The second error is that the UT's reference to the purpose of the legislation is infected by an erroneous analysis earlier in its decision. In particular, starting at paragraph 147 at page 201. Paragraph 148, the Upper Tribunal says that the statutory context for construing in connection with is found in the policy objectives of the BPRA rules, and in particular in the definition of qualifying business premises. The reason they're saying that is that they correctly state at para 147.3 that the degree of connection requires depends on the statutory context.
So what's the error?
The error is what they then go on to do from para 149 onwards.
So this is right. So you accept 147 and 148, do you, so far as it goes? I thought you might challenge number 2, 147 sub 2, that it's to be given a broad meaning. That you might not be content with that, but perhaps you are.
My lady, it's not that I'm not content with it. It's more that it's analytically valueless to say it's broad, because the analysis required is much more nuanced than that. I mean, it's common ground that in connection with is broader than an on test.
Yeah.
But that's really as far as one can go, because the next step, as we've seen from the authorities, is to look at the particular statutory context and work out, well, what degree of connection, what sufficiency.
So 2, you say, doesn't really add anything.
Indeed.
Might just as well not be there. Once you've decided what the degree of connection is, you've decided the breadth of the meaning to be given.
Exactly right. Yes, that's my submission.
Okay, so we've got to 147 and 148. We now go to the error, do we?
Yes. So 149 and following, the UT gives its decision on what it considers the statutory context to be. It starts at 149 and finishes at 157. So, just working through this, at 149, the Upper Tribunal quotes from a consultative document. My submission is that that document is not particularly instructive. Our focus is on what the legislation says. But I do note that what the Upper Tribunal takes from this document is entirely consistent with my submission about what one can take from the legislation. The focus is on redevelopment and refurbishment to bring buildings back to a standard suitable for occupation.
Yeah.
Then over the page, a key error is at 151. And in particular, the final 2 sentences.
Yes.
The Upper Tribunal says that the target of the relief is not a converted or renovated building, but a functioning building which is open for business and being used for a trade or as an office. That is what must be delivered for the relief to be available. That is wrong. Relief is available if the premises are available and suitable for letting for use. You do not have to deliver a functioning building which is open for business in order to claim BPRA.
And indeed, to have a functional building, particularly a hotel, you'd have to fill it full of furniture, bed linen, and all the other stuff that a functioning hotel needs, which couldn't possibly qualify.
Indeed. Indeed. But that's a key error of law at 151. At 152, the Upper Tribunal recites HMRC's submission about what in connection with means. And at 153, the Upper Tribunal rejected it. They say that HMRC's argument fails to recognise that the relief is not designed to encourage conversion or renovation in itself, but rather to encourage activity which will result in unused buildings becoming buildings actually used for trades or as offices.
So that's to confuse, is it the policy objective with the purpose of the statutory language? So the statutory language goes as far as it goes. It may be that the reason Parliament put that through is because it wanted to pursue a broader policy, but you say a distinction needs to be drawn, do you?
Indeed, my lady. I think there are 2 points here. The first is that the emphasis on open for use, ready for use, is misplaced, for the reasons I've given. The second is that insofar as one does find of value drawing on policy points of the sort my lady Justice Whipple just put to me, our argument does acknowledge the fact that the relief is, may well be to encourage buildings to come back into use, because a building is more likely to be used if it's newly renovated or converted. It's improving the physical state of the building. And presumably that is what was supposed to encourage tenants to move into the building and thus regenerate the area. So that's where the Upper Tribunal goes wrong in relation to 151 and 153. I'll have to come back to these passages when I deal with a particular point in relation to the franchise costs. But just sticking with the IFA and promoter fees, we were looking at paragraph
283 and following.
Indeed. So we were looking at 286.
Yeah.
And the final sentence. Where the Upper Tribunal makes reference to the purpose of the legislation. And my submission, that's infected with an error of law.
What's the evidential basis for the last half of that sentence? The conversion could not have taken place without the equity financing being raised.
My submission is that's an error. I'm about to come on to it. That's an error in my submission. So just to take a step back, I said there were 2 essential building blocks for the UT's decision in relation to the IFA and promoter fees. And one is about the purpose of the legislation. I said there were 3 errors in relation to that. I've just looked at the second of those, which is the erroneous analysis earlier on in the decision. The third error is the assertion in the final sentence of paragraph 285 that HMRC's interpretation of the legislation would operate to restrict and reduce the effectiveness of the regeneration of disadvantaged areas. My submission is that there is no foundation at all for that, either in the wording of the legislation, which is what matters, or in the evidence, which matters less. If the court is interested, I'll give you the transcript references for some evidence given by HMRC's technical and litigation read. The reference is supplementary bundle 4, tab 87, page 943. And at internal page 5, line 23 and following, Ms. Nash sets out essentially what sort of BPRA claims HMRC is seeing. And the evidence was that the vast majority of BPRA claims are very small. They're made by individuals, small businesses, not by large groups of investors. There's no warrant for the UT to say that unless BPRA can be claimed on IFA and promoter fees, the effectiveness of the regeneration of disadvantaged areas is going to be reduced. The idea that the arrangement we're considering here as some sort of paradigm as to how BPRA was intended to operate is simply not the case. There's no foundation for it at all. So those are the three errors that I submit are in the first of the UT's building blocks for its conclusion. The second is final sentence of 286, and the second sentence of 285, the conversion would naturally require equity investment for such a project. And my submission is that there are three errors here as well. The first error is that if the Upper Tribunal is suggesting that this building could not have been converted into a hotel for £6 million without almost £700,000 of IFA and promoter fees being incurred, there's no foundation for that. The FTT made no such finding, nor could it have done so in the light of the expert evidence it heard. The Upper Tribunal's second error is that it appears to have regarded the IFA and promoter fees as analogous to a financing fee like a bank arrangement fee on a loan. My submission is that's not correct. There are at least three material distinctions. Distinction number one is what is being paid for. My submission is that fees for promoting a tax shelter structure are not being paid for the same thing as an arrangement fee on a loan. A bank arrangement fee is a fee for finance and finance only. You're not inviting the bank to become a member of an LLP which owns and operates a hotel for the best part of a decade. Distinction two is the amount that's being paid. The arrangement fee on the co-op loan was £87,500. That's the arrangement fee for the co-op loan of gross £7 million. The IFA and promoter fees, which led to members investing £7.2 million, was £682,000, almost 8 times higher. And I do say that is a relevant consideration. One is considering what Lords Hailsham, Wilberforce and Salmon were saying in Benedetto about being alive to the scope for abuse and discouraging different taxpayers receiving materially different allowances for the same activity. Distinction three is the connection with renovation or conversion works. Bank loans are a common feature of renovation and conversion developments. IFA and promoter fees are not.
Suppose a company decides to undertake this kind of project and decides to finance it by an offer of shares. Do merchant banks' fees be allowable as equivalent to the bank arrangement fees?
I don't think I'm in a position to answer that, my lord, for two reasons. One is that it would depend on, among other things, what the evidence says. You have my two necessary components, so not too remote, and a natural real-world connection to renovation and conversion. One would, my respectful submission, wish to test the expenditure that my lord's put to me by reference to those those components, and it's really important to undertake a detailed analysis of the facts and what's going on with this expenditure. The second reason is that I would need to seek instructions from my clients. The Upper Tribunal's third error in relation to this is that the honour in connection with test doesn't pose a test of causation. understand that to be common ground. I take that from my learned friend's response skeleton at paragraph 55.2. But in any event, it cannot be right in my submission for a taxpayer to be able to say, I structured my arrangements in a particular way, which as a necessary part of that meant I had to incur this particular expenditure, and therefore those fees necessarily qualify, and that's the end of the story. A more nuanced analysis is required. So my submission is that the Upper Tribunal made material errors of law when it dealt with this issue, and its decision should be set aside. Right. I'm going to turn to my learned friend's submissions. In their response skeleton, which is in the core bundle at page 68, behind tab 3. Begins at paragraph 54, but I think the submissions begin in earnest at paragraph 56. And they make essentially 3 submissions, which break down into a number of submissions. Their first submission is at paragraphs 56 and 57, and they say that in connection with is broader than on. We've covered that. They refer to the Benedetto, which I've taken you through. Their second submission is at paragraph 58, and they say that whether the IFA and promoter fees qualify as questions of fact. Yeah. I've addressed that. Their third submission, which is over the page, paragraphs 59 to 60, is that the conclusions of the FTT and Upper Tribunal were correct. And this breaks down into, I think, four points. Number one, they say at paragraph 59.1 that without investors' equity there'd be no funds to convert the property. I've addressed that. The second point at paragraph 59.1 is that Mr. Smith's evidence highlights that this is precisely why Parliament chose to enact legislation allowing tax relief for expenditure incurred on or in connection with. And they make a similar point at paragraph 60. Say that's misplaced for 3 reasons. The first is they've given a reference to paragraph 4.28 of Mr. Smith's report. I don't think that reference is correct, or at least it doesn't bear out what my learned friends cited for here. So we don't need to go there, but it's bundle page 867 in the 3rd volume of the supplementary bundle. The second point is that it's respectfully not for Mr. Smith to decide what Parliament's intention was in enacting this legislation. It's a matter for construing the wording of the legislation. And the third reason it's misplaced is that, as I've referred to, the evidence was that the vast majority of BPRA claims didn't involve these sorts of arrangements. The LLP's third point is at paragraph 59.2, where they say that the structuring of these arrangements was normal practice, and they refer to Mr. Smith's evidence. The court will have the point that what Mr. Smith was giving evidence on is what's normal in the context of tax schemes. Yeah. That's not of any analytical value. The fourth submission is at paragraph 59.3, So there's no distinction between a bank arrangement fee and these IFA and promoter fees. And I've addressed the report on that.
Well, in fact, they're turning your Benno Decker point against you, saying equality of treatment as between different ways of raising the money.
Well, the LLP argues that our approach would introduce an irrational distinction. My submission is it's not irrational. We've seen from Benedetto concerns about the idea that different taxpayers should be able to claim different allowances for doing fundamentally the same activity.
Yeah. Right.
Those are my submissions on HMRC's primary case in relation to the IFA and promoter fees. I'll turn now to HMRC's alternative case. I'll assume you're not with me on my primary case for these purposes, and that the IFA and promoter fees do qualify by analogy with some sort of financing cost. I'll say up front, I'm going to focus on the important point of principle for this court to determine. And the important point of principle is this. Where a fee is paid to raise money, and that money is spent on a mixture of qualifying and non-qualifying items, can 100% of that fee qualify for BPRA, or is an apportionment necessary? And this is essentially returning to the point I began with this morning. And put shortly, our alternative case is that the IFA and promoter fees are paid to raise money, and 50% of the money raised is spent on non-qualifying things like land. It must follow, we say, that the IFA and promoter fees cannot qualify in their entirety. Otherwise, relief would be given in connection with the acquisition of land. A fee has been paid to raise money to buy land, and if you allow that fee in its entirety, you're giving relief in a situation where Parliament has specifically said relief cannot be given.
Yeah.
That's the submission. I'm not asking this court to carry out the apportionment analysis itself or prescribe the appropriate methodology. I'm asking the court to determine the point of principle. If the court's with me, then the matter can be remitted to the FTT for the apportionment exercise to be carried out there. So that's, in a nutshell, what my alternative case is. I'm now going to turn to how the FTT and Upper Tribunal approach this and identify the relevant areas of law. I will say a complicating factor in this particular appeal is that the UT's errors include not actually addressing the key or a key point, which was specifically whether this was a mixed fund of equity and debt from which all of the LLP's expenditure was paid. And an additional complicating factor is that my learned friend say in their skeleton that certain arguments weren't advanced to the UT. So I'm going to have to spend a few minutes showing what was argued below, but I will do that as quickly as possible.
Yes. Yes, bear in mind you've got to finish this morning.
I certainly will finish this morning. So, we begin with the FTT's decision. In fact, perhaps I'll start with some context. So, we argued in the FTT that the IFA and promoter fees don't qualify for BPRA, so we advanced our primary case. The LLP's argument in response is that this is properly analysed as a fee to raise money. And a fee to raise money is connected with what the money raised gets spent on. So we argued in response, well, in that case, clearly not all of the fee can qualify because the money raised is not spent exclusively on qualifying items. It's also spent on acquiring the land. there was no answer to that submission as a matter of fact. So the factual proposition that members' funds were used in part to acquire the land was not contested. All of the submissions are in the bundle. I will read out the references, but I'm not proposing to take the court to them. There are 6 documents that I'll give references to. Number 1, HMRC's FTT skeleton, para 249, F, which is volume 4, tab 91, page 964.
Page 964.
64.
Right.
Document 2, LLP written closing submissions, paras 193 to 197. That's in the supplementary bundle, volume 4, tab 92, pages 973 to 974. Document 3 is HMRC's written closing submissions. Paras 307, 319, 323, and 324. That's in volume 4 of the supplementary bundle, tab 93, pages 1008 to 1013. Document 4 is the LLP's written notes on HMRC's closing submissions and the comments on paragraphs 307, 314, 323, and 324. That's volume 4 of the supplementary bundle, tab 94, pages 1026 to 1027. Document 5 is the note of HMRC's oral closing submissions, paras 270 to 271. That's in the supplementary bundle, volume 4, tab 95, page 1040. And the final document is the transcript of the LLP's oral reply submissions. That's the transcript of day 16, internal page 121, line 24, to internal page 122, line 11. And that's in the 4th volume of the supplementary bundle, tab 89, page 947.
Right.
It's beyond doubt, factually it is the case that this was a mixed fund. The reading list for this court lists all the evidence. My lord indicated that the court has read the contents of the reading list. So the court will have seen the information memorandum says it, the bank statement shows it, the witnesses accepted it. And as I'll show you in a moment, it's even common ground in this court if one looks at my learned friend's skeleton arguments. So that's the context. We now look at the FTT's decision in the core bundle, tab 8, page 348. Oh, sorry, tab 18, page 348. So it's decision on our alternative case is at paragraph 201 and 203, first sentence. That's the FTT's decision on this argument. But notably, the FTT does find in HMRC's favour in relation to the developer fee, or the residue, even though in principle it's essentially the same point. fee is paid, it's referable to qualifying and non-qualifying items, it therefore can't qualify in its entirety, should be apportioned. So the FTT reaches inconsistent conclusions, and HMRC apply for obtain permission to appeal on that basis. So if we now turn to HMRC's Upper Tribunal grounds, please. That's in the 5th volume of the supplementary bundle. Tab 100. Page 1122. And there are...
Do you want us to turn this up? Or are you just giving us references?
Could the court turn this document up, please?
So this is HMRC's grounds of appeal
Correct.
to the
To the Upper Tribunal.
the UT.
Paragraph references are 22.C and 25.C. So 22.C is at page 1128.
And 25.
25C,
Yeah.
page 1129. So we argued that the FTT was wrong not to apportion by reference to the
Yes.
entire package, as per the residual sum, mechanics profit, or the developer fee.
Yeah.
I'll give you the references to our UT skeleton. That's in the 5th volume of the supplementary bundle, tab 102, page 1158. Paragraph references are 79, 81.3, and 82. And our complaint in relation to apportionment was, number one, the FTT hasn't actually explained why it's rejected our case. There's an inadequacy of reasons there. But number two, in any event, it was wrong to do so on whatever view. Then we get to the Upper Tribunal hearing. The court has indicated it has already read the passages of the transcripts.
What is the point you're drawing from this? You're rebutting an argument that says you didn't argue this. Is that the point?
So the court's indicated it's already read the passages that I asked the court to read. If I may, I'll spend 5 minutes drawing the court's attention to the key passages. It's in the 5th volume of the supplementary bundle. Tab 97. I'll take this as quickly as I can. So, the first page of this document is page 1043. At lines 16 to 23, I advance the submission that the alternative case is that an apportionment exercise is required, and it's by reference to all of the non-qualifying expenditure, not just the land.
Yes.
Page 1074. From line 22 to the following page, line 9, I make the same point. The fees are referable to a package of non-qualifying items, including but not limited to the acquisition of freehold. Page 1076, lines 2 to 13. I said what cannot be disputed, and what I understood not to be in dispute was that the funds raised by the LLP were used to purchase the land, so this was a mixed fund. I then gave the Upper Tribunal various references. And at page 1077, I summarised the submission.
Yeah.
The point is, again, it's not limited by reference to the acquisition of the land. Over the page, I think this is something that the court didn't read. At line 10, page 1078, Mr. Justice Michael Green asked for an illustration of how one would carry out the apportionment exercise. And I give him an illustration starting at line 14 on page 1078 to line 7 on page 1079. So those were the submissions I made in opening the appeal on this point.
Mm-hmm.
My learned friend's responsive submissions are behind the next tab, tab 98.
Well, you've shown us you argued it. Do we really need to go through all this?
Well, the reason why I'd like to show the court this is...
All right.
So the apportionment argument begins at page 1093, line 18.
Sorry, I've lost my space. Am I in a different transcript, different tab? Where am I?
You're in tab 98,
Yep.
page 1093.
Yep.
The apportionment argument begins at line 18. And at page 1095, at lines 2 to 8, we have the responsive argument. So it's a remoteness argument that's being advanced. And at lines 9 to 14, my learned friend says if the Upper Tribunal isn't with him on the remoteness argument, then one would be in an apportionment scenario. Between lines 15 to 21, there's a question about was any part of the equity finance for the acquisition of the freehold. And at lines 20 to 21, my learned friend says one can't say that. If one jumps forward to page 1099, at line 21, Mr. Justice Michael Green asks...
Sorry, 1099.
Correct. Line 21, Mr. Justice Michael Green asked what evidence the FTT had to conclude that none of the equity finance was used for the acquisition of the land. Over the page, my learned friend says between lines 2 and 5, he didn't think there was any evidence on that point. And on the same page, from line 19, Mr. Justice Michael Green puts to my learned friend that it's pretty obvious that by the time the money came in, it was just one pot of money, and it was being used for the whole 15.5 million. And my learned friend's response is, if that's the view that the tribunal ultimately forms, then we would end up in the apportionment exercise. It's over the page, lines 1 to 5.
Right.
Now, just to finish this off, behind tab 99, we're into the following day. Page 1108.
1108.
Yes. Lines 12 to 17, my learned friend advances the submission because the debt is secured over the property. It would be logical to infer that none of the equity was used to buy it. He then repeats at lines 18 to 25 that if it is a mixed fund, the apportionment exercise is necessary.
I haven't got that. I'm on lines 12 to 17 on page 1108. Is that right?
Yes.
Logical to infer that it was the bank debt ranking behind. Is that the bit you want me to look at?
Yes. a little bit more context might be provided if one starts at line 9. So,
Yeah.
I then reply. So one jumps forward to page 1114, please. So page 1114, line 21. I note that my learned friend submission is one can't say that the equity finance was used to acquire the freehold. He sought to take a factual point against me, that's not right. Then over the page, this morning my learned friend said this issue was not explored by the UT, that's simply not right, and there's no foundation whatsoever for the assertion that because the bank debt was secured against the property, it's logical to infer that the bank debt was used exclusively to purchase the property. Now I then go on to take the UT to all of the evidence. Right. If one jumps to the conclusion of that at page 1120, at line 17, I make the submission that although it's unclear why the FTT rejects our alternative case, it either didn't do so on a factual basis or it wasn't open to it to do so on a factual basis. It's not open for the LLP to raise such an argument for the first time now. It wasn't raised in the FTT, nor in response to our notice of appeal, nor in the skeleton arguments. That's it with the transcripts. Thank you very much for bearing with me. There are 4 points that I take from what the transcripts show. The first is that, consistently with HMRC's grounds of appeal and skeleton arguments, the apportionment case was advanced by reference to all the non-qualifying expenditure, not just the acquisition of the land. Secondly, I provided the Upper Tribunal with an illustrative apportionment methodology with which my learned friend didn't take issue. Thirdly, it was common ground that if all the money went into a single bank account from which all of the expenditure was paid, an apportionment exercise was necessary. And fourthly, the Upper Tribunal needed to decide if the FTT had rejected our alternative case on a factual basis, i.e. on the basis that not a single pound of members' money had been used to acquire the land, whether that was a conclusion that was open to the FTT on the facts. That's why I took the UT to all of the evidence.
Yeah.
So that's the context. Now I'd like to go to the Upper Tribunal's decision. Core bundle, tab 12, page 231. It's paragraphs 287 to 289. The nub of the decision is at 289. The first point to make is that the Upper Tribunal gets the figures wrong in the first sentence. The relevant borrowing from OVL was 1.3 million, not 2. Perhaps more importantly, in paragraph 289, the Upper Tribunal makes 3 errors as set out in our appeal skeleton at paragraphs 80 to 83. The first error is that the Upper Tribunal focused on the land exception, not the broader argument that the apportionment exercise should be carried out by reference to all of the non-qualifying expenditure. The second error is that the Upper Tribunal said it's by no means obvious how any apportionment could be carried out on a principled basis. That's an error for 4 reasons. Number 1, I gave the Upper Tribunal an illustration of how it could be carried out. The Upper Tribunal didn't address that. Number 2, it was common ground that if this were a mixed fund, an apportionment analysis was necessary. Number 3, it was ultimately a matter for the FTT to carry out the apportionment exercise. Number 4, the Upper Tribunal says that the BPRA claim already excludes the land element and that no part of the acquisition of the land was included in the BPRA claim. That assumes the very point in issue. The equity funding was used in part to acquire the land, and so in claiming the cost of raising that finance, the LLP is including within the BPRA claim expenditure in connection with the acquisition of the land. The Upper Tribunal's third error, and this is the point made in our skeleton argument, paragraph 82, is that the Upper Tribunal said that the thrust of HMRC's appeal is that the FTT should have found as a fact that the acquisition of the land was sourced wholly or partly from equity. There's an error of law there for 2 reasons. First, as we've seen, there was no dispute about that before the FTT. This factual point only came up during submissions in the UT. The second error is that my submissions to the UT were advanced on the basis that it wouldn't have been open to the FTT to reject our submission on a factual basis. And the Upper Tribunal simply didn't engage with that. It should have addressed my submission, but it wasn't open to the FTT to reject the submission on the factual basis, because that would have been a very clear Edwards and Bairstow error of law, which is why I took the UT toward the evidence. The Upper Tribunal can't just recite HMRC's complaint without actually determining the complaint. So for those reasons, my submission is that this court should determine that the Upper Tribunal erred materially in its review of the FTT's decision. Its decision should be set aside and the court should redo the review, and the court should proceed on the basis that all the money did go into a mixed fund from which the LLP's expenditure was met.
Well, on the footing that it did all go into a mixed fund, some of which was used to buy the land and some of which was used to pay for works and some of which was used for other things, does it follow on your argument that the bank arrangement fee needs apportionment as well?
Strictly speaking, I think that would follow logically. Obviously, that isn't the approach my clients have taken.
No.
They allowed the bank arrangement fee and
Indeed.
they disallowed the IFA and promoter fees. Logically, I think it would follow.
I was going to ask a related question, which is going back before apportionment, or going back to your primary case.
Yes.
Whether you can elaborate, maybe you can't, on the distinction between bank fees, which I understand were in practice allowed, and equity, particularly in the context of Benedico and the equality of treatment, because even in relation to bank fees, you could make the same point that if allowances are given for that element, that gives a different result for someone who funds a conversion with bank borrowings as compared to someone who funds it from their own resources. So a number of these points seems to me potentially apply to the bank fees. Now maybe you can't help us because the bank fees aren't before us.
I don't want to repeat submissions I've already made, and I've already made submissions as to why in my submission the nature of an IFA and promoter fee is different to an arrangement fee on a loan. I can repeat the submissions.
Yeah, we've got your submissions. Thank you.
I mean, ultimately, the question is whether the statute construed purposefully was intended to apply to this expenditure.
Well, I think you've shown us that Mr. Lewis included bank arrangement fees in the Argus software,
Yes.
but not IFA and promoters' fees except in tax-driven investments.
Indeed, yes. So I think bank arrangement fees would pass the test, as it were, of the two components that are missing in relation to the IFA and promoter fees. They're not missing in relation to the bank arrangement fees, because they're not fees to invite the bank to join this LLP for 8.5 years. They're a common part of real-world commercial property development and so on.
Yeah. And I think if you're doing a development appraisal, you include bank arrangement fees, whether they are incurred or not, simply in working out what the eventual value and profit is going to be.
Yes, and because it's a perfectly straightforward means of financing a property.
Right, that's the fees. Now do we go on to franchise?
Just one final point, which is that if we're wrong in our analysis that there should be an apportionment in this scenario, then we advance the argument in our appeal skeleton at paragraph 84, which is that we've got here fees that are connected to the acquisition of land and other things. And I made a submission this morning that in those circumstances, the fees can't qualify in their entirety. The choice is apportion or disallow the entirety. Our preferred analysis is apportionment, but if the UT is correct that it's not possible to apportion on a principal basis in this scenario, then it would follow in my submission that none of the fees qualify.
Yeah.
I'm going to turn to the franchise costs. This involves two items of expenditure. The first is a payment to Ramada. I will say up front, this is a small amount of money, but it does give rise to an important point of principle, specifically whether BPRA are available in respect of the acquisition for use by a party other than the taxpayer of intellectual property rights, and in particular a license for that other party to operate a business at the relevant premises.
So are we concerned only with the $15,000 paid to use the brand name?
Correct.
There was some technical advice that Ramada gave. I don't know what the nature of the advice was, but your appeal against that is no longer pursued. So only concerned with the right to use the brand name.
That's correct.
Which I suppose is what, a trademark license, is it?
I'll show you the license, but yes, one. And your lordship is correct. We didn't pursue an appeal against the, confusingly, I think it's £15,000 under the technical services agreement, because that fee was in relation to the works of conversion and making sure that the works in particular were in accordance with the standards set by Ramada.
Yeah.
So that's the first of the franchise costs that we're interested in. The second is what's been described as the sanguine payment, which is the payment of $248,000 made to sanguine who were hoping to get a job managing the hotel business but lost out. The FTT decided that payment didn't qualify, but the Upper Tribunal disagreed. The skeleton references are HMRC appeal skeleton, paragraphs 85 to 89, and the LLP's response skeleton, paragraphs 69 to 73. I'll start with the Ramada payment. I'll address it in three stages. First, what the payment relates to. Secondly, why we say it doesn't qualify. And thirdly, I'll look at how the tribunals dealt with it and where we submit they went wrong. As regards to the first stage, what the payment was for, the FTT describes the fees paid to Ramada in its decision at paragraph 19. paragraph 119 on page 330. And one can see from the sublist 1 and 2 that Ramada get two separate fees for two different things. $15,000 so that the operating company can have a license to use the Ramada brand, and £15,000 relating to the technical services agreement. For your note, because this is relevant because of what something my learned friend saying there, Lewison, some additional detail is added by Mr. Tracy in his witness statement at paragraphs 78 to 79. That's in volume 2 of the supplementary bundle, tab 39. My reference for that is wrong. I'll provide it after. But the point made by Mr. Tracy is a fee for two different things. One is the intellectual property rights, the other is cooperation in relation to the development. The franchise agreement is in the 5th volume of the supplementary bundle at tab 104, page 1169. It's there because it was added later. It should be in the 1st volume, but a charge is there instead. For your note, clause 1 of that agreement at page 1117.
I haven't got that in my electronic version. Can I later?
We will rectify that when the supplementary bundle is updated.
Well, you can't update it now because I've repeated my version.
I apologise, my lady. I was thinking of the additional page that will be added. I'll provide copies separately.
I've got it on the hard copy. It's just not in the electronic version. Not in the PDF.
I apologise for that.
Yeah.
So clause 1, page 1173 is the grant of the licence to the operating company, and clause 6 at page 1187 provides for the initial fee in return for the licence.
Sorry, clause 1 and clause
6.
Thank you.
The technical services agreement is in the 1st volume of the supplementary bundle, tab 15, page 302. We don't need to go there, but clause 2.01 makes clear that what's being provided is consultation services relating to the design, site plan, decoration, and other technical services. And at clause 2.02, provided that Ramada will assist in supporting the hotel to be planned, designed, constructed in conformity with the relevant standard.
You didn't argue for an apportionment of this on the basis that it related in part to furnishings.
We did not argue for an apportionment of it. I will say I'm not very close to the arguments about furnishings and so on, so I don't know whether there would have been anything objectionable to this. But the answer to my lord's point is no, we didn't argue for an apportionment. So that's, in a nutshell, what the two payments to Ramada were for. Turning to the second stage of my submissions, which is why the franchise cost of $15,000 doesn't qualify. My submission is that the focus of the legislation is granting relief to renovated buildings. It's not about subsidising the cost of the business that is then carried out from that building, whether or not the business is carried out by the taxpayer itself, or as here, another party. So the point of principle with potentially wider ramifications is, can expenditure that concerns the operation of the business from the building after it has been converted qualify? We say not, it's too remote. That's the submission. I've shown you the legislation already. So you have my submission on its focus on physical works. The third stage of my submissions is to look at the FTT's and UT's decisions. We start with the FTT. I've already shown you at paragraph 119 that the FTT correctly recites that it's paid for two different things. Apologies, that two payments are made to Ramada for two different things. At paragraph 155 on page 339, the FTT finds that the legislation shouldn't be given so wide a construction so as to provide an entitlement to relief on all expenditure associated with creating a fully functioning hotel business. My submission is that that's correct. But where the FTT goes wrong is at page 350. In fact, the paragraph before, paragraph 208 at page 349, we have the recitation of the submission, and then the conclusion at 209. We've looked at 209 before, and you have my submission that the rejection of any need to consider sufficiency of connection is an error of law. A further error is the conclusion in the final sentence. And we say there's an error of law there because the FTT has materially misconstrued the definition of qualifying expenditure and reached a decision not open to it.
Well, except that the FTT, as we can see from 208, is dealing with both the $15,000 and the £15,000 complicitly.
Indeed. So there are three specific errors in 209. One of them is that it elides the two payments incorrectly and forgets its earlier correct recitation of the fact that the payments related to two separate things, and one of them is a license. It's an intellectual property right.
Yeah.
That's the first of the three errors in 209. The second is that it wrongly dismisses as irrelevant the fact that this expenditure isn't even concerned with the LLP itself. It's a license for London Luton Hotel 2010 Limited. And the third error is that, as I've already said, it dismisses the idea of considering sufficiency of connection, and it fails to apply its correct self-direction at 155, that one cannot construe in connection with as so wide as to provide relief on all expenditure associated with creating a full functioning hotel business.
Yeah.
Turning now to the Upper Tribunal's decision. This is at tab 12, page 239. paragraph 324.
Or in fact, it's open for business point, aren't we?
Yes, so the UT says the concern of the legislation is in effect the end product of business which is operating.
Yeah, and you've already made submissions about that.
So the relevant question is, was this hotel available and suitable for letting for use for the purposes of a trade without the license to use the particular franchise? The answer to that is yes.
Right.
Just for your note, my lord, in its earlier consideration of the definition of qualifying business premises, there were two paragraphs that I didn't take you to, but I flagged were relevant to the franchise arguments. The first of the two is paragraph 154, which is page 202.
Yes.
And at 154, they say that the definition of qualifying business premises is based on use, and then they add in brackets and availability and suitability for use of a building rather than its just physical state. The difficulty here is that the fact that the definition involves consideration of availability and suitability for use shows that the definition is not based on use. It is based on physical state. It doesn't have to be used. And the second paragraph reference that we haven't been to is 157 over the page. And here the Upper Tribunal takes issue with what the first tier said in paragraph 155. And it essentially draws on what it said previously in saying that they don't like it. So that's infected with the errors that I've already shown you.
Yes.
So that's where we say the Upper Tribunal went wrong.
Mm-hmm.
As regards what my learned friends say in their skeleton, at paras 70 to 73, they essentially make 2 points. One is that they say that the FTT's mistake, as I characterise it, in alliing the two payments was in fact based on Mr. Tracy's witness evidence. In fact, if one looks at Mr. Tracy's witness evidence at paragraphs 78 and 79, it's very clear that they were made for the two separate things that I say they were made for. The second point they make is to endorse what the Upper Tribunal said about the purpose and interpretation of the legislation, and you have my submissions on that.
Yeah.
So I'm going to turn now to the sanguine fee. I'll show you the FTT's findings and reasons why it held the sanguine payment doesn't qualify, and then I'll turn to the Upper Tribunal's decision to overturn the FTT. The FTT's decision starts relevantly on this point at paragraph 55, page 300.
Paragraph 55, did you say?
Correct, yes. Page 300. So that's what they find in relation to the sanguine payment. Its decision that this payment doesn't qualify is at page 349. Paragraphs 206 to 207.
Give me the page numbers again.
Page 349,
349, yeah.
paragraphs 206 and 207.
Yes.
So I submit that the FTT was right there, the reasons it gave. Now turning to the UT's decision at page 236. The UT sets out at paragraphs 310 to 314 the FTT's decision on completing submissions. And its decision is at 315 to 317. My submission is that the Upper Tribunal erred in law here for 3 reasons. The first is that the Upper Tribunal's conclusion is based on its erroneous interpretation of the legislation. We've already looked at paragraph 317 and the reference to a key to obtaining BPRA is that the converted property must operate as qualifying.
Yeah,
business
we've got
premises.
your point about that.
The second error is that I do submit that it's not a finding open to the tribunal, properly directed as to the law, to find that payment by the LLP to smooth over the business relationship between the developer and Sanguine bears the necessary connection to the renovation and conversion of a building, which in the event Sanguine has no involvement.
Well, I'm not sure I understand that. Payment wasn't made by the LLP. It's made by Cannock. And,
Yes,
and the Upper Tribunal say at paragraph 312 that that payment was not in the list of payment obligations undertaken by OBL. It was paid before the development agreement was entered into. And then at 315 they say the fact that OBL chose to make the payments whether or not out of its profits not material. What matters is the right stroke obligation obtained by the LLP for its expenditure. Well, what right or obligation was that?
Yes, it's rather curious what the UT says here.
I mean, consistently with their earlier approach, that should have been the end of that one. It was paid by the developer out of its money with no obligation given to the LLP to do so. So, if anything, it falls into a so-called residual sum.
My lord, the response to that is as follows. Number one, the FTT recited that my learned friends accepted that the LLP knew that Cannock would have to bear this cost to fulfill its obligations under the development agreement. That's FDT 206, and there was no appeal against that.
206.
Yes. Page 349. there was no appeal against that. There's never been a sanguine payment specific appeal on the basis that it's not to be analysed as a constituent element of the development sum. The UT is somewhat ambivalent about this. It says at paragraph 312 that it's not in the list of payment obligations, but it does then say the parties agreed that the obligation in relation to the sanguine payment should nevertheless be considered in the same way as the other specific items, and we proceed on that basis.
So it's being treated as if it were an obligation, is that right?
Well, we have an FTT finding that there is an obligation under the development agreement with no appeal.
I'm not sure you say that, but is that what the FTT actually say? They say that it was accepted that the LLP knew that the developer would have to make the payment in order to comply with its obligations, but that doesn't mean that it was obliged to make that payment necessarily, does it?
Yes, I mean, you could say the same, for example, of the developer's overheads to meet its various obligations to run its business.
Well, in my submission, the FTT is saying that CANEC has to bear this cost to fulfil its obligations to the LLP under the development agreement.
Yeah.
That's what it says, its obligations under the development agreement. And there's no appeal against that.
But your point of principle is not really dependent on that. Your point of principle is that the connection is not sufficient.
Correct. I have two points of principle in relation to it. Just to finish off this particular thread, though, your Lordship is correct. The Upper Tribunal does say that an invoice indicated that it had been paid before the development agreement was entered into. I have no idea what that is based on. I found the invoice last night. It's in the bundle. I can show the court, but it indicates that it was paid on the 29th of March.
That's 4 days later.
Yes. So I don't know what that was.
Right.
What that was based on. So my submission is the UT's erred in law for 3 reasons. Given the court the first 2, so number 1, based on an erroneous decision on what the purpose of this legislation is, and that it's key to operating. It's key that the converted property is operating as qualified business premises. Number 2, that it's not open to the tribunal to find that a payment of this nature qualifies for BPRA. Number 3 is that the Upper Tribunal doesn't appear to have identified any error of law on the part of the FTT. It substitutes its own judgment for that of the FTT. That is, I say, clear from how it puts this. It says we consider that the sanguine payment was made in connection with the conversion, albeit at the outer limits of that phrase. It appears to be saying its view is this payment is one side of the line, the FTT found it was on the other side. It isn't saying the FTT made an Edwards and Bairstow error of law. In my submission, deciding that the sanguine payment falls one side of the line, albeit at the outer limits, and therefore overturns the FTT, is not something that was open to the UT to do.
Is that right? I mean, they found that the FTT was looking through the wrong end of the telescope. The FTT was looking at what the developer spent its money on, and that led them to set aside the FTT's decision. So weren't they at that point in a position to remake the decision on their own without identifying discrete errors of law for each particular point?
In my respectful submission, that is not what the UT is doing in its decision. It's saying that it is proceeding on the basis that it is a constituent element of the development sum, in common with the position taken by the parties. It doesn't say anything in paragraph 317 about the FTT looking at the wrong end of the...
No, I follow, but it's much earlier on when they're dealing with what they call issue 1. Where was that? Yes, it's paragraph 96, 97. I'm not quite sure. They say, since the error was material, that part of the decision must be set aside. But I'm not sure which part they're talking about.
I think it may just be issue 1.
Yeah.
Although on this part of the decision, didn't take us earlier, I've lost it for the moment, to the UT also finding that the FGT made too sweeping a statement at 155.
Yes.
So they were identifying an error of approach in this context.
So I'm trying to be fair to the UT and look at what they say in paragraph 317. They don't make reference at 317 to the fact that they thought the FTT went far in relation to not construing in connection with to provide relief on all expenditure associated with the hotel business. That doesn't seem to be the reason for what the UT does at 317. What the UT does at 317 is say, okay, we've got this language of in connection with. The FTT finds that it doesn't fall on the qualifying side of the line, and we disagree. But it hasn't identified a particular error of law on the part of the FTT. It hasn't referred to the paragraph that my lady just referred to. My reading of 317 is essentially that it thinks that the payment falls on one side of the line, and the FTT found that it found the FTT found that it was on the other side of the line. If that is right, then we would be in the sort of middle ground that my Lord Justice Lewison put to me yesterday, where one might, if you're not with me on my second argument, facts, what my Lord put to me is that you could have a situation where there are facts that are capable of satisfying the test, but the fact-finding tribunal decides that they do not in fact do so. And you have my submission that no fact-finding tribunal properly directed could find that this payment qualifies. But if I'm wrong about that, then we may well be to the ground that my Lordship referred to. Just on this point about whether the FTT looked through the wrong end of the telescope, or whether the error that the UT found in relation to issue 1 was in some way material to this. I just want to make a couple of points, if I may. The first is that although the UT says that the sanguine payment isn't specified in terms in the schedule to the intercreditor deed, franchise costs are specified, and that has been the heading that the parties have been using to argue in respect of this expenditure, even though it's somewhat of a misnomer. So that's the first point I'll make. Just to develop that slightly. So the UT says in its decision, well, not clear whether it is part of the payment obligations, but it hasn't made a positive finding to that effect, and it's treated it as a constituent element of the development sum correctly. Right. The second HMRC's case in relation to the constituent elements of the development sum does not depend on HMRC finding a contractual obligation in respect of each and every item of the expenditure that's in dispute. And this is a point made in our response skeleton argument behind tab 6 at page 119. Paragraph at the top of the page that doesn't have a number is saying that the UT was perfectly entitled, perfectly correct when examining what the constituent elements of the development sum were to have regard to the contractual arrangements, and the fact that the developer was obliged to provide certain items of expenditure to the UT. That's part of the analysis of what the LLP is getting for its money. But our case doesn't depend on showing that each and every constituent element of the development sum is the subject of a contractual obligation. The point is that a contractual obligation is sufficient but not necessary.
Yeah, that's what you say in your footnote 5.
Exactly, exactly. So even if the position is that the sanguine payment isn't the subject of a specific contractual obligation, our case is exactly the same. Because the question is, does the LLP's expenditure qualify for BPRA? In answering that question, the court has to take an unblinkered view of the facts. That involves considering the purpose of the LLP in making the payment. That's very clear from Tower. What the LLP received in return for the payment. Contractual rights are part of that, but not necessarily the whole story. And if the LLP knows and intends in paying the money to procure a certain outcome, it's a perfectly sensible and correct conclusion that that outcome is one of the objects of the LLP's expenditure. It's a constituent element of the LLP's expenditure. So here the LLP knows and intends in paying the development sum that it was going to procure the outcome of sanguine receiving the sanguine payment. That's abundantly clear from, among other things, the debt finance request. And so it's perfectly sound to treat the sanguine payment as a constituent element of the development sum, regardless of whether there's a specific contractual obligation that relates to it. My Lord, I said I would give the court the correct reference to paragraphs 78 and 79 of Mr. Tracy's witness statement. That's at Supplementary Bundle, Volume 2, tab 39, pages 624 to 625.
Yeah.
My Lord, that's all I wish to say on franchise costs.
Right.
Unless there are any questions. May I hand
very
back
much
to my learned leader, Mr. David?
Yes, Mr. David.
My lord, my ladies, good morning. The court will be pleased to hear that we are, by my estimate, within about 4 minutes at the end of the revenue submissions. You've got a minute or two from me and then a minute or two from Mr. Brinsmead Stockham. 2 topics, number 1, ground 5, and then number 2, coming back on a point in relation to the capital account that the lady Justice Falk raised yesterday. In terms of ground 5, it's simply to say this. The court has the submissions that I made yesterday. The court also has the revenue skeleton argument at paragraphs 90 to 94. There's nothing substantive that I want to add at this stage. As I've said, ground 5, we say, has an ancillary or supportive character. It's about whether the court, the Upper Tribunal, may have failed to join the dots in a way which has a knock-on effect
Yep.
on the particular points that it had to decide. The court has heard some submissions already in that regard. So we've had this question of what, if anything, one can properly take from the ES valuation when one comes to consider the question of whether the development sum in its entirety was qualifying expenditure. The court has had the question raised, at least implicitly, whether the capital amount should be seen essentially as a bolt-on feature, something different. And there'll be more said in the responsive submissions, including in relation to the licence fee. But that is all that I want to say for now. Just sort of make sure they the court realises where we are on ground 5. And with that said, I'm going to hand over to Mr. Nzinsoka.
Yes, Mr. Wittgenstein.
My lord, my ladies, one very quick point. Just for context, I was making submissions about the commercial construction of the capital account deed, and the court will recall I was saying it gave the court the maximum protection possible on HMRC's construction. My learned lady asked a question, Lady Justice Falk asked about the co-op loan and whether there were any restrictions on borrowing on the LLP, and one might have expected such restrictions if the co-op was concerned about credit risk of the LLP. My lady, it's tab 6.
This is SB1, is it?
SB1, yes, tab 6, page 196. And it's clause 10.31, little b.
Mr. Nzinsoka, start again. Which tab am I looking at?
Sorry, my lady.
Tab
Tab
6.
6, page 196.
Sorry, that relates to what code, isn't it? Oh, shall not and shall procure. Okay.
Yes, so just to read it out, because I'm conscious the text is small. The borrower shall, so the borrower, the LLP, shall not, and this is the co-op loan, so it's the loan, obviously, from the co-op. The LLP shall not and shall procure the London Luton Hotel, which is OPCO, shall not, 1, incur or be the creditor under any borrowings over the sum of £50,000 in aggregate if with the same lender, other than borrowings permitted under this agreement, so the co-op loan, the developer-borrower facility agreement, which is what I call the developer loan, and the developer London Luton Hotel facility agreement, which was the loan that OVL made to OPCO, or 2, enter into any arrangement with any other bank or financial institution for the provision of banking facilities over the sum of £50,000 in aggregate, if with the same lender, in each case without obtaining the bank's prior written consent, save that it is acknowledged and accepted by the bank that the existing developer security is in place, and as far as the bank is aware, continues to remain in force. The existing developer security is a defined concept, as one would expect. It's essentially, as I understand it, securities that were in place in relation to other developments that had already been put in place. So just 2 points to make on that. One, this in my submission does limit the borrowing or seek to constrain the borrowing of the LLP, and it's the co-op expressly seeking to do that. So I would rely on that as being entirely consistent with the submissions I made. I'd also note that it specifically identifies the co-op loan and then the 2 loans made by OVL as being the sources of borrowing or indebtedness that the LLP was envisaged to have. So in my submission, that is the co-op seeking to constrain the liabilities of the LLP to those arising under those specific agreements. And so in my submission, that again points against the argument of my learned friend and to some extent the reasoning of the Upper Tribunal, that clause 3.5.3 or a withdrawal under that clause might lead to some freestanding claim in restitution. Here, the co-op is seeking to constrain it just to the known borrowing under those contractual agreements that are specified in that clause. Unless I can assist further on that point, those are my submissions. And I think that's all of our submissions.
Thank you. Mr. Gavin, do you want 10 minutes now, or do you rather start clean after the short adjournment?
My lord, thank you. I think I'd prefer to start after adjourn, if only because I need to do a certain amount of reorganisation.
All right. Well, in that case, let us break now, and we'll resume at 10 to 2. don't feel you need to use all your allocated time.
No, I hope I will be brief.
10 to 2.
Well,